Well, the only purpose one can use 164 is for contradiction and corroboration. And that also, how is to be done, is laid down in the evidence. The wife came and said someone has killed. Now, if the wife has to say someone, she will not say someone unless, because it's her husband. She will say my husband has killed. She will not say someone has killed.
His conduct is really unbecoming, your lordship. He was sleeping inside, maybe he was sleeping inside. Other person also saw him sitting on the veranda, my lord. The eyewitness doesn't say that
but
he was the
wrong.
perpetrator.
This is wrong. The judge could not have taken judicial notice.
Lordship, whatever may be, but that part she has not disclosed the name that the accused person is the perpetrator. That part it's not there.
May it please your lordships, my lord. The lordships would recollect this is that matter, my lord, where the son is accused of assaulting his own mother, and so his wife had initially deposed. Later, she had turned hostile. 161 and 164 was taken. However, those were not proved, madam. The 164 was never proved. And on one question, your lordship actually wanted to know, because the trial judge had taken judicial notice of the statements made under 164 in order to convict the accused, my lord, whether that could have been done, my lord. That was one question which your lordship had posed on us, my lord. My learned friend had also taken time to look into that. On that occasion, I had already given your lordship the Madras decision. And just to, my lord, to make that position clear, my lord, Section 157 of the Evidence Act itself makes it clear, my lord. If your lordship may kindly have 157 of the Evidence Act, 157 of the Evidence Act for a moment, my lord. I'll recapitulate the facts, but first let me address your lordship on this point. Section 157. Former statements of witness may be proved to corroborate later testimony as to same fact. In order to corroborate the testimony of a witness, any former statement made by such witness relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate the fact may be proved. Well, here what 157 says, how, for what purpose it will be used. Number one, it is for corroboration alone, and corroborating not with corroboration. Basically, what happens sometimes because of a related witness, if the during investigation the IO is taking the evidence of a related witness, the IO may feel that later he might recite, or maybe his testimony may have a cloud of doubt. Therefore, they are produced before the magistrate for 164. Tomorrow, when that witness is produced in the court, suppose he says whatever he has said in his 164 also, my lord. But the court, there is a doubt whether his testimony is correct or not. In that situation, the 164 comes handy, my lord, to corroborate. It is only to corroborate his statement, nothing else. That is 157. And 145 is for contradiction. If your lordship kindly see 145, why I am saying showing these two sections, because the only purpose of 164 is for contradiction and corroboration and nothing else. And I'll place the decisions also, but under the Evidence Act only, it is very clear. The only purpose for which 164 can be used is for contradiction, which is under section 145. How to do that is laid down in 145. For corroboration, which is laid down in 157. And this corroboration is not for corroborating a corroboration. This is for corroborating the substantial evidence adduced in the court. Now, the first decision, my lord, that I would like to place is of 1960. This is AI 1960 Supreme Court 490. Well, the other decisions, I have extra copies, but before I just go to that, let me place the 1960, my lord.
Read it slowly.
Just one paragraph, paragraph 18. The additional session judge observed in his judgment with reference to Agarwal as follows. After the quoted portion, my lord, what is mentioned by the Honorable Supreme Court. It is clear, therefore, that the learned judge relied on some statement of Agarwal recorded under section 164 of Criminal Procedure Code. The statement under section 164 referred to was not specifically put to Agarwal, even to contradict him. Statements recorded under section 164 of the code are not substantive evidence in a case and cannot be made use of except to corroborate or contradict the witness. an admission by a witness that a statement of his was recorded under section 164 of the code and that what he had stated there was true would not make the entire statement admissible, much less that any part of it could be used as substantive evidence in the case. Just like our case, my lord. The additional session judge therefore erred in law in using the statement of Agarwal under section 164 to come to the conclusion that he had been won over. And the only purpose that one can use 164 is for contradiction and corroboration. And that also, how is to be done, is laid down in the evidence.
So, Mr. Goswami, that we have understood. That's very simple.
Yes.
The statements 164 is only for contradiction or corroboration.
Yes, my lord.
160 are only for contradiction.
Yes.
But that's not the point here, perhaps.
No, your lordship wanted to know whether the trial judge, because the trial judge, if your lordship recollects, said now we will take judicial notice of the statements made in 164.
That perhaps is not permissible.
That is not permissible. Your lordship wanted a decision on that. That 1960 is direct on that point. I have privy councils and also Allahabad High Court all on that same point. If your lordship wants, I can place it.
If the witness was confronted with the 164 statement and it was exhibited and proved,
that would have been a different
by a
situation.
witness, then it is a different matter.
Right. That was not done here.
Otherwise, judicial notice
Could not have been taken.
Let us see what she says.
My lord. And otherwise, on facts, I don't think I need to reiterate because.
No, you see, there is just one issue here.
My lord.
When we say charge not proved beyond reasonable doubt,
My lord.
this expression must be given a due meaning.
Absolutely.
Although, since the case of that Vriddhi Chand Sharda 1985 Supreme Court has laid down the law very clearly that each link in the chain of circumstances must be established. There should not be any possibility of any other probability of any other outcome. And therefore, the court must be convinced that it is exactly what the prosecution says has happened. That would amount to proving a charge beyond reasonable doubt. It doesn't say a charge is to be proved beyond all reasonable doubt.
Absolutely.
That's not the law.
Basically, there should not be any doubt.
Right.
All doubt should be
So
removed.
therefore, in a case where whatever be the evidence, whatever be the links in the chain, if the court comes to a conclusion that this is enough to rule out
Absolutely.
the possibility of any other occurrence, then can it not be said that
Yes,
the charge
yes,
has
my
been
lord.
proved beyond
Absolutely.
reasonable doubt?
But only thing here, my lord, that that has to be on the basis of some substantive evidence, well, not on the basis of a suspicion.
Correct. So
Here-
now,
Now the case, as I understand, my lord, is resting on some suspicion which is very strong. But however strong that suspicion
what
is,
is
my
that
lord,
suspicion?
that 164 statement, which obviously that created some
No, no,
suspicion,
you please forget the 164 statement.
and the fact
There are
that he
three or
had,
four circumstances have been established.
yes, my lord,
One, that the incident happened in the courtyard of the house.
correct, my lord,
Second, that the
he was sitting there,
victim used to live at that time
yes, yes,
with his mother.
yes, his presence,
Then he was present.
yes,
It was a homicidal death.
yes,
There was no explanation.
yes,
Correct. Perhaps, if I remember correctly, the IO had seized a dao also. But
yes,
maybe
which
that's
was led by him.
it was
According
led
to the witness, he had produced it from the kitchen.
right. So that would come within, that would be a fact which can be proved under section
27 of the Evidence
of
Act.
the Evidence Act. There is no dispute to that. That
No,
has been
these are the
notwithstanding.
circumstantial evidence which are there.
If you stitch these circumstances together, where is the scope to doubt that something else might have happened?
Yes,
If you
my
can
lord, that is
address the court on
definitely
that.
one view, my lord. And if your lordship is of that view and rules out any other hypothesis, then of course the
No, what is the
Correct.
other hypothesis?
Well, like,
The
only
wife
thing-
said that
Somebody else.
somebody else has come.
that was consistent with she has said it immediately before PW2, and then she also says that in her own evidence. That is the only thing, that someone assaulted mother-in-law. That's what she said
No,
to
but
PW2.
someone assaulted could mean even her husband.
Maybe.
Someone else, she doesn't say.
But some,
Of course, we can't take note of her 164. Otherwise, there she has said
yes,
that to
yes,
save her husband, she has come up
yes,
with this
yes.
story.
But that is, she said, then I went to house. When I went to the house, my sister-in-law told me that someone assaulted my mother and fled away towards the river. This is by the informant PW. This is when he had gone to the.
All right, so let's just brush through the facts once
Well,
again very briefly, and then we'll
very
close
well.
the matter.
Very well, my lord. May I start with the FIR, my lord?
Yes, yes.
Humble submission is that around 10:10, today that is 16:10:15, when the complainant's mother so-and-so was preparing meal, an altercation took place between her and her elder son, Ron Bahadur Chetri, over land and property. Ron Bahadur demanded money from his mother, but as his mother refused to give him the money, he brutally hacked at his house, at his mother with a dao, thereby causing her grievous injury. The injured person was taken to Lekhapani, Margarita for treatment, and eventually she was referred to AMCH at Dibrugarh, but the doctor declared her dead. This is by PW2, the brother of accused. Then PW1 is the doctor at page 9. 3 injuries, these are in forehead, head, and neck, my lord. PW9 is the iron. May I just read this?
Yes.
On 16/10/2015, I was attached to Lekhapani police station. On that day at about 4 p.m., one Prakash Chetri came to the police station and lodged a written izahar, stating that on that day at about 10:10 a.m., his mother Indramaya Chetri, aged about 69 years, while working in the kitchen, his elder brother Ron Bahadur Chetri quarreled with his mother on property dispute and later assaulted his mother with a dao, causing injuries on her person. While the injured was taken to the hospital at Lekhapani, the doctor referred her to Dibrugarh, wherein the doctor declared her dead. At that time, I was officiating as OC Lekhapani police station. On receipt of the ijahar, I registered Lekhapani police PS case number so-and-so, and I took the investigation myself. Exhibit 2 is the said ijahar, and exhibit so-and-so is my signature with endorsement. I interrogated the informant at the police station itself. Thereafter, I went to the place of occurrence, that is the house of accused. Arjun Chetri visited the place of occurrence and found Arjun Chetri in the house. I noticed clotted blood in the courtyard of the house. On being asked, Arjun Chetri did not reply anything. I also met the wife of Arjun Chetri there. Then I took the accused Arjun Chetri in my custody. I also recorded the statement of the witness found there. I prepared sketch map. Thereafter, I brought the accused and his wife to the police station. I again interrogated the accused Arjun Chetri and recorded his statement. I also recorded the statement of the wife of the accused at the police station. On interrogations, Srimati so-and-so, wife of the accused, disclosed that when there was a quarrel between the accused and the deceased, she was plastering the floor of the house and she came out after hearing the cries of the deceased. She noticed that her husband was standing there with a dao in his hand, and she had seen her husband assaulting 2 tanks with the dao upon the deceased. Thereafter, Arjun Chetri slipped away towards the kitchen, washed the dao, and went inside the house with the dao. Thereafter, she raised alarm. Then neighboring people gathered, and with the fear that the villagers may assault her husband, she narrated them a story that the deceased was assaulted by one mad person. She also disclosed that thereafter the villagers searched for the mad person, but they did not find any mad person in their area. She also disclosed that her husband used to drink regularly, and after drinking, he used to quarrel with his mother for property. She also disclosed that 2 days prior to the incident, the deceased had sold a pair of bullock for so-and-so, and that money was, and with that money, and the accused was demanding the said money from her. This is relevant. Thereafter, I again interrogated the accused. The accused admitted that he had ill feeling for his mother, as she was not giving him proper share in the property and for which he had assaulted his mother, but not with the intention to kill her. He also admitted that he has washed the dao and has kept the same in the kitchen and was able to show it. Next day, I seized the dao as shown by the accused from the kitchen of his house. Exhibit 3 is the Caesar list, and so is my signature. I took thumb impression of the accused on the Caesar list. The accused was arrested and thereafter he was forwarded to the court. So and so and also forwarded to the court with a prayer to record her statement under section 164 CRPC. Thereafter, that may not be so much relevant. During the last portion, my lord, during investigation, I recorded the statement of witness Bhadramaya Chhetri. This witness stated before me that on the date of incident, this is regarding the 161. That is reflected there. During cross, if your lordship finds the second last from the second last, that witness Sobha Chhetri did not state before me that Chandan Chhetri, son of accused, disclosed before them that his father inflicted cut injuries towards the deceased. It is PW3. If your lordship recollect, PW3 said that the son of the accused had come and said. So this was never told in 161. That link has been established by the defense. Then I did not send the seized out to FSL for examination. Now, PW10, that is another brother. This indicates how the mother was taken to the hospital and where she died.
Ms. Bhuya, you please address us on this point. That this testimony of the IO
Yes.
regarding the wife, PW5, informing him or disclosing about these things, that is not a statement by the accused.
Yes.
She was not an accused.
Yes.
So even if it is made in a police station,
Yes.
will it be hit by 25 and 26 of the
I
evidence?
think it will not.
If not,
Yes.
whether this will be admissible evidence?
It is admissible.
You
Yes.
address
Yes.
when it finishes.
So, my lord, therefore, what is clearly proved here is that the circumstances, my lord, that the accused was present in the house, the accused and the mother stays in the same house, my lord, that they used to quarrel sometime, my lord, that has also come on record. And after the incident, my lord, witnesses have seen that he was sitting in a chair, my lord, to that conduct, and the fact that he had led the discovery of the dhow, my lord, under section 27. But ultimately, whether that dhow was because it was never sent to FSL and there was no blood, so whether that was used or not, that part is not established. However, he has produced a dhow, my lord.
And that dhow has been seized by the IO on being shown by
the police, my lord.
And therefore, you also have to come to this point at some point of time, that this testimony of the IO regarding the PW5 disclosing to him, this is the circumstance, that has gone unassailed.
My lord.
During cross, there is no challenge to that.
My lord.
Now, will it not be admissible? Because it is not a statement by the accused.
However, my lord, that is a statement made under 161. The witness, PW5, this is her statement under 161.
No, but IO says that he has heard it.
What he recorded under 161. IO was referring to the 161 statement. IO was only referring to the 161 statement, my lord. Now, 161 statement cannot be used, my lord. That is not substantive evidence, and it can only be used for contradiction, not even for corroboration.
Yes.
There is no other independent witnesses who says that PW5 has said something to them inside the police station. That is not the case. IO is referring to 161. IO said, I interrogated PW5 and this is what she stated in her 160. This is what the 161 is, in fact, at page 80. It is there also in the paper. So he was only referring to that for contradiction.
Yes.
So now only with these, my lord, and in fact, my learned friend had prepared a chart for your lordship's perusal, which, in fact, I had also done some work on that, and we have made it a chart like this for prosecution and defense. So here, the points which my learned friend has given is in one side, the prosecution side, and from our side, whatever we had to say, we have given it. So this indicates, my lord, we are only left with those 3-4 circumstances alone. Now, if those circumstances are strong enough to indicate that the guilt has been done by the accused alone and no one else, of course, then your lordship, that conviction will be upheld. But if there is a doubt, my lord, then certainly, my lord, that will go in favor of the accused, my lord. Because
So according to you, what is the doubt here?
from the records, my lord, if I go from the records, my lord, at two witnesses have confirmed that wife came and said someone has killed. Now, if the wife has to say someone, she will not say someone unless, because it's her husband. She will say my husband has killed. She will not say someone has killed. That was immediately after the incident. This has been brought by the prosecution, my lord, PW2 and PW3. They both have said that. That is there on record, my lord. To that effect, my
So
lord.
someone has killed can mean two things depending on the context.
Generally, my lord, if it's her own husband, she will say my husband has killed. She will not say someone
Or
has killed.
rather, it could be quite the other way around. She might not
And
have,
fled towards the river.
might not have preferred to take the name of her husband.
But that is, my lord, these are
That is
presumptions.
what she says in the 160.
True, my lord, these are presumptions. That is why I'm saying that two views. Now, when there are two views, of course, my lord, then it will go in favor of the accused, my lord. There are two views in the matter, my lord. One, which your lordship is saying, the other also, because they have brought it. If those two things were not there, then of course, my lord, perhaps, my lord.
Yes, what is worrying is PW5 is prosecution witness.
Lordship, in the instant case,
Hmm.
the circumstances which goes against the accused person is that Lordship, he killed his mother. Allegation is he killed his mother. His mother was lying in the courtyard in an injured condition. He did nothing. Sole eyewitness is the wife. First of all, she reported the matter to her in-laws, brother-in-law. Lordship, natural instinct is that at the first point she might not have. Lordship would implicate her husband, my lord, because being a husband. At the same point of time, since she is the wife of the accused person, naturally, your lordship, she will not implicate in general condition. Wife will not, unless it is proved, my lord, unless it is a fact, my lord, unless it is true, will not implicate falsely her own husband, my lord. That aspect your lordship will look into. She has implicated her own husband.
Where? How?
In a 161 statement, she has implicated.
No, but that's not evidence.
Yes, but it was since she has turned hostile, the IO has cross-examined her, your lordship, and there she has, lordship may kindly come into the evidence of the IO, your lordship.
Yes.
The informant Prakash Chetri is my brother-in-law. Accused Arjun Chetri is my husband. Deceased Indramaya Chetri was my mother-in-law who used to reside with us in our house. The incident took place about 9 months back. On the day of incident around 9 a.m., I went to the field along with the cows, and when I returned back home, I found my mother-in-law lying on the ground in injured condition. At that time, my husband was found sleeping inside the house. On being asked, my husband replied that he did not see who has assaulted my mother-in-law. My statement was recorded by the police. The witnesses declared hostile with the prayer of the prosecution, and prosecution is allowed to cross-examine. As she has turned hostile, although she is a prosecution witness, the IO has cross-examined her. It is not a fact that I did not state before the police that on the date of incident, my husband asked money from me and my mother-in-law, but we
Ms.
refused
Bhuya,
to.
sorry to
my lord.
interrupt. You see, we can understand that
Yes.
despite being a prosecution witness,
Yes.
she was declared hostile.
Yes.
Therefore, her testimony would not be binding.
Yes.
But merely by bringing on record the contradiction,
My lord.
does it prove anything? It doesn't prove anything. It's just that it only neutralizes her evidence which goes against the prosecution. That's all. Nothing beyond
The
that.
presence of the accused person is proved by all the other prosecution witnesses and his conduct, your lordship. Then thereafter there is leading to discovery. And whatever has been stated by the prosecution witnesses, that after the commission of the crime, he washed a weapon and thereafter he kept it in the kitchen. An accused person led the police to lordship to that place only where he has kept it, your lordship. And whatever has been stated by the prosecution witnesses, my lord, that the assault has been made on the head and chest and all, it was proved by the medical evidence. And your lordship, 164 statement, your lordship on the other day made a query. It was not exhibited. and the magistrate was also not examined. In that event, your lordship, under 391, your lordship, 311, your lordship exerted power. But it not, I think it not serve any purpose because nothing has been discernible from the one.
No, she doesn't even say what she has stated.
Yes.
She has only admitted
Yes.
that her statement
Yes.
was recorded.
Yes.
But in her deposition also, there is no mention as to what she had stated.
Yes.
She has only said that her statement was recorded and by the magistrate, where she has said that hearing hue and cry, she rushed and found her mother-in-law lying on the ground with blood stain. That's neither here nor
And the ground was stated by PW2 regarding motive part. There was a quarrel because the victim did not pay money to the accused person. Even that fact was deposed by the wife of the victim also, wife of the accused person also, that there was a quarrel because they refused to give money to the accused person. And a conduct in the lordship is absolutely unbecoming. Being the son, my lord, mother is lying in an injured condition, a serious state. He's just sitting mum, your lordship. He did not do anything, my lord. So all this lordship.
Is there, in this case diary, is there an endorsement regarding the disclosure? I mean, the recovery of the weapon?
Lordship, it was on 17/10/2015. Date of offense, date of offense. 16/10. Date of, yes, 17/10/2015, 9 a.m. So left for one number Udaipur, Bhujal Basti along with staff and arrestee. Arrived at Bhujal Basti at one number Udaipur with staff and arrestee so. Now and on as being laid by the arrestee Sri Arjun Chetri, I have recovered and seized the weapon used by him in committing the murder in presence of witnesses in connection with the case. That was.
So can you please mark that?
Yes. That regarding the hostile part, your lordship, may I refer one judgment?
Yes.
2011.
But before that, should we just have a look at the findings of the learned trial?
Yes. Para 20, page 50.
We can start from 24. Yes.
The IO during his evidence testified that he got the statement of Bhadramaya Chetri recorded in 164 CRPC. Inadvertently, the said statement was not exhibited, though the said statement is in the case record. Therefore, I have taken judicial notice of the said statement under 164 of the CRPC of Sri Bhadramaya Chetri. In her statement under 164 CRPC, she stated on oath that at a relevant time her husband was quarreling with his mother for money for purchasing liquor, and she heard hue and cry of her mother-in-law, and she rushed to her and found her lying. Lordship, in a 164 statement, if your lordship takes into account this part, the eyewitness doesn't say that
but
he
this
was
is wrong.
the perpetrator.
This is wrong. The judge could not have taken judicial notice.
Lordship, whatever may be, but that part she has not disclosed the name that the accused person is the perpetrator. That part it's not there.
Even in the 164.
164, lordship, may
164 she has.
I have taken judicial notice of the said statement, so and so. In a statement under 164 CRPC, she stated on oath that at a relevant time her husband was quarreling. Quarreling part is there, but for money, for purchasing liquor, and she heard hue and cry of her mother-in-law, and she rushed to her and found her lying on the ground in a pool of blood. The assault part, I think it's not. Quarreling part is there.
That only.
Quarreling part is there, but the assault
that is correct.
Not.
But
yes.
This first part of para 24,
yes,
where the learned judge has said
yes,
that although it has not been exhibited,
yes,
I am taking judicial notice.
That
is not
permissible.
That's wrong.
Yes,
because these statements are not evidence. It is to be used, as he said, only for contradiction or corroboration.
Yes.
So if there is nothing to corroborate and if the question of corroboration doesn't arise, contradiction probably it would have been, but that was not used. So there is no question of taking judicial notice.
But
yes.
Lordship, if your Lordship leaves apart that part, 164 statement, Lordship, other factors, I think.
Let us see what
yes.
is the finding. Yes.
Money purchasing liquor, and she heard hue and cry of her mother-in-law, and she rushed to her and found her lying on the ground in a pool of blood. PW5 saw a dove in the hands of her husband, and she gave her mother-in-law water to drink. The statement under 164 is corroborative evidence, and the statement so and so of the wife of the accused lends support to the prosecution. Thus, we find that the evidence of IO lends support to the prosecution case that it is only the accused person who killed his mother in the Chetri with cold blood. PW 5, page 29. Question number 5, page 29. PW 5, that is, a wife, Srimati Bhadramaya, adduced in evidence that around 9 a.m. on the day of Okram, while returning home after tethering the cattle in the field, she saw that her mother-in-law Indramaya was lying injured in the ground, and he was sleeping inside the house, and that on being asked, he replied that he did not know as to who had killed his mother. Yes, my wife stated correctly.
Yes, but then this is not incriminating evidence.
No, that but presence part, presence of the accused person at the place. His conduct is really unbecoming, your lordship. He was sleeping inside, maybe he was sleeping inside. Other person also saw him sitting on the veranda, my lord. And the injured was lying, lordship, in a serious condition. Thereafter, she was taken to Dibrugarh Medical College, where she has expired. So, your lordship, whatever the all the circumstances proved to give against the accused persons, my lord. My submission is that. And non-examination of this one, my lord, magistrate.
Non-examination of?
The magistrate, your lordship, who recorded the 164 statement and non-exhibiting that statement, your lordship. At this stage also, your lordship may do so by referring the matter to the learned trial court.
So here you are saying which part of the evidence of PW5 can be relied upon? Which part finds corroboration?
Lordship, corroboration part regarding the presence of the accused person, regarding the leading to discovery. Presence is well proved by all the evidence, all the witnesses.
These are things even he has admitted.
Yes. Quarreling, taking the lordship may give the benefit to the accused person, taking into account there was quarrel. That your lordship may convert it, my lord. Because there was sudden quarrel before the commission of the crime, so that advantage may be given to him, my lord. And other lordship, although lordship, she turned hostile, my lord, may I take your lordship once again to the evidence of PW5?
Yes, please.
Lordship, and one more factor, the accused son informed PW3, although he is not examined, that is not fatal, because other witnesses prove that he was there. Lordship, he reported the matter to PW3, stating that accused person has assaulted his grandmother, Chandan Chetri, to PW3. Then the evidence of lordship PW8, accused was found sitting in front of the side of veranda. So there was blood, your lordship. Bloods were found, my lord, in his courtyard, my lord.
All right.
Blood was noticed on the courtyard of the accused person.
Okay.
These are the circumstances goes against him.
Just one decision on section 27, madam. You've given a print, I think. This is reported in 2011, volume 11 Supreme Court cases at page 724. The relevant para is 25. Para 25.
Just for a minute.
Para 25, which is at page 731, internal page. Is your lordship got it?
Yes.
With regard to section 27 of the Act, what is important is discovery of the material object.
Just a minute, you said para?
25. With regard to section 27 of the Act, what is important is discovery of the material object at the disclosure of the accused. But such disclosure alone would not automatically lead to the conclusion that the offense was also committed by the accused. In fact, thereafter, burden lies on the prosecution to establish a close link between the discovery of the material object and its use in the commission of the offense. What is admissible under section 27 of the Act is the information leading to discovery and not any opinion formed on it by the prosecution. So, discovery has been done, but as seen, my lord, that dove was never sent to FSL. There was no blood stain. So, its use otherwise has not been proved. That is what initially also I tried to say, my lord. So, perhaps even this is a weak piece of evidence or may not be under 27 months.
All right, so that's all. We'll close it.
My lord.
Heard Mr. K. Goswami, learned senior counsel, appearing as amicus curiae. in this case. Also heard Ms. B. Bhuya, Learned Senior Counsel in APP Assam, appearing on behalf of the state stroke respondent. Arguments concluded, judgment reserved. Yes.
Deeply obliged.